Justice Amy Coney Barrett, thank you so much for the time.
Thank you for having me, Brett.
You know, the title of this book, Listening to the Law.
There it is.
Why?
Listening to the Law by Amy Coney Barrett. So, yeah. So listening to the law, reflecting on the court and Constitution.
Did you write it?
I wrote it because I really love the court and I love the Constitution, and I wanted to invite people to experience the court and Constitution with me.
And was part of it demystifying the court or the process?
Yes. You know, I speak to a lot of school groups. I speak to young children. I speak to lawyers, non-lawyers, all kinds of people. And I get the same questions across groups. How does the court get its cases? How does the court decide cases? Do the justices get along? And I can't answer all of those questions one-on-one, but I can write a book so people can find the answers if they're interested.
Yeah, I've read it. And there is a lot of mystery and intrigue about what happens inside these walls. And the perception of that, like everything else in Washington, is that it comes from a partisan point of view, that there are somehow teams here, depending on which president nominated you for the position. But you write about things like the assigned seating in the court and what you wear when you go to the courtroom, and basically how the outside perception is not the inside reality.
That's right. You know, we don't wear red and blue. We all wear black because judges are nonpartisan. And the idea is that we're all listening to the law. We're all trying to get it right. We're not playing for a team. We don't sit on specific sides of the bench, left and right. You know, we sit in order of seniority.
You'd hope.
And when you listen to the perception about how it's done, what is your thought about that?
Well, there's a disconnect between what happens inside the court and what people think happens inside the court. I often ask new law clerks, what surprised you most when you started? And one of the most common answers is the difference between what's happening on the inside and what people think is happening on the inside.
So, for example, in fact, the focus is always on these divisive cases and decisions, but there are a number of unanimous decisions that the media doesn't cover every year. I mean, we have 42% in this past term, 2024, 45% in 2023, 47% in 2022. You write, one who follows the court casually might be under the impression that practically every case is decided with the appointees of a Republican president on one side and the appointees of a Democratic president on the other. While that breakdown sometimes occurs, presenting it as the norm grossly distorts the court's work.
That's absolutely.
Well, actually, it distorts how the courts is supposed to work or how we believe it's supposed to work. Like, let's be honest here, but we do understand that that does actually happen. Like, you do fill the Supreme Court up with people who think the same, then you're going to get a lot of things are going to come out your way, depending if you're the president.
I mean, here's the thing, though, right?
Yeah.
So they can sit there and be noble and be stoic, but they were appointed by a partisan president for a reason. Like,
exactly,
there's a reason that Obama was fighting over getting his Supreme Court justice in before Trump got in office. There's a reason that Trump was fighting to get his appointment in office before Biden got in office. You know, this idea that they're not partisan or don't have partisan bias when they're appointed is absolutely laughable to me.
Yeah,
and I think you're being and I'm saying this because, like I said, she was appointed by President Trump because President Trump saw Republican and conservative values in her. Same thing with the previous justice that he appointed. Like this, yeah, sure, they're supposed to be nonpartisan, but go ahead and put a gun bill in front of them and see how they rule. Go ahead and put abortion rights in front of them and see how they rule. It is always split down the middle. Like these high-profile Democrat versus Republican cases, the ones that were appointed under a Democrat are leaning left, and the ones that are appointed under a Republican are usually leaning right. With the exception that Republicans sometimes side with Democrats.
All right, man.
Absolutely right. You know, last year, I believe it was 6 cases, you know, roughly around 10% cases broke down by party of appointing president. That's a pretty small number given the overall number of cases that we're hearing.
It might be a small number, but what were those 6 cases?
The current perception, like I said, is that the left is saying this
Mm.
court is protecting President Trump and his effort to consolidate power. You can see that really from the recent headlines. There's a lot of them about that. The overwhelming evidence that the Supreme Court is on Donald Trump's team. New York Times, the Supreme Court is backing Trump's power grab. NBC, in rare interviews, federal judges criticize Supreme Court's handling of Trump cases. They say you're helping to certify this move towards authoritarianism. How do you respond to that?
The court decides cases as they come. And one thing that I try to emphasize to students, and one thing I try to do in the book, is place the court in the context of history. We're not deciding cases just for today. And we're not deciding cases based on the president, as in the current occupant of the office. We're deciding cases about the presidency. So we're taking each case and we're looking at the question of presidential power as it comes. And the cases that we decide today are going to matter 4 presidencies from now, 6 presidencies from now, and so on. Each of these cases that we're getting, well, I mean, some of them overlap, but many present different constitutional issues.
Mm-hmm.
Yep.
The right obviously looks at it completely differently, saying federal district judges around the country are overstepping. They're unelected, making sweeping decisions about a president's executive power. When you have to deal with those, it often comes in the emergency docket, which is something different that people don't fully get. Can you explain that?
Sure. So the emergency docket, these are not cases that come up on our regular October term merits docket. Those cases are the ones that I primarily focus on in the book. There are about 60 of them per year, and they proceed very slowly with briefs and oral argument and a lot of deliberation. These emergency motions come up when a case has not fully been decided and settled in the courts below, and they ask for the court's emergency intervention to enter a stay, usually, or sometimes to lift a stay, to maintain a particular status quo while the issue is being litigated in the courts below. So it's not a definitive resolution.
Thank you.
It's what Justice Kavanaugh calls the...
Man, please explain that for that, Monty, because a lot of people don't understand what she's saying.
So, and it's sad, and I'd like to say I don't believe you, but I've seen proof of that. People do not understand what an emergency stay is. It's usually, like she said, it's usually a restraining order of some sort has been placed on somebody or hasn't been placed on somebody. So, for example, like Kilmore Garcia.
Yeah.
Supreme Court stepped in and said he has to come back. That's an emergency order. That was laid down because there's not time to sit there and let it go through the whole process. Or like a gun rights issue, like when a gun rights issue hits the Supreme Court's desk, if the lower courts have said, "Oh, yeah, we're gonna rule on the constitutionality of extended magazines or normal capacity magazines," then they're like, no, that's going to infringe on people's rights, and that's the argument. So we need to hear this now before we just decide that judges are going to litigate things or make laws.
Thank
So
you.
this idea, like it's to provide relief when what it is supposed to stop harm from being done, whether it be harm because of something's been restricted or something's been allowed, and it's in the cases where like she said, it hasn't been fully decided. A judge just put an order in, and there's ambiguity. I can't say words.
Ambiguity.
in the law, and if that law is left ambiguous, there could be harm.
All right, man. Shout out Monty.
Interim during the interim.
There are a lot of them, though. This administration has filed almost 24.
There have been a lot.
And is that because you see more federal district judges stepping in and doing that?
I don't know. The phenomenon of cases being brought on our emergency docket started a few administrations ago. There were some in the Obama administration. There were some in the Biden administration. And now we do have, it seems like we're on a trajectory to have more in the Trump administration. I don't know. I think it's a combination of, increasing use over time, not just this administration, of executive orders. And I think that all the judges, district judges too, are just doing the best we can with a lot of litigation that's been filed.
Most times you're not saying, again, about the merits, you're saying about the process and specifically what should or shouldn't happen at that time as the case is progressing through the system.
Exactly. It's just, what is the holding pattern going to be? What are we going to do for the interim while the case is litigated?
So
it does not
for
mean
example,
that we have
Seth,
reached any.
Yo, what's up?
so for an example, the district court in California or Texas or whatever basically said that the ATF's rule on 80% frames and receivers um, was constitutional, like that they could regulate that, even though the GSA said that they couldn't or didn't say anything about it. Well, that went up to the Supreme Court, and the Supreme Court was like, no, you're going to get injunctive relief because the status quo has been that you can have frames and receivers, 80% frames and receivers. And the status quo has been this: you can't just change the law by executive fiat. So they issued an order protecting people through, I think it was FPC and GOA, and so it kept the status quo the same, even though the people, the litigants, plaintiffs wanted to change it. So that's just one example. It's like you keep the status quo of what's been going on, unless what's been going on has enough merit that it would likely win in the on honest merits. So
All right.
it's an interesting process, which is why it takes so long for an issue to go through the courts, which is a reason why Democrats love to say, "Oh, let it go through the courts and quote unquote due process," because they know they can just tie it up for 4 years until the
Yeah.
president's out of office, and then hopefully they get someone that's favorable to their position, and they just drop it and make it a moot point.
Yeah, that's why they try to say things like what expedited deportation or expedited
Is
removal is.
unconstitutional or some
Yeah.
shit. Yeah, because it hamstrings the president. It has traditionally been allowed, and because you don't like it now there's going to be argument over it. So the order from the district court is, oh, you have to stop doing that. Well, the Trump administration just goes and said, hey, Supreme Court, this is how we've been doing it. Why is it a problem now? The case can continue and go up through its normal merits, but we want this injunctive relief for this situation,
And here's the thing they
and they
don't know,
get it.
man. They've been doing that since Bill Clinton. But all right, let's get back to it.
Any definitive resolution about the constitutional or statutory question in a case.
In June, ruling on one of those cases, Trump v. Casa on birthright citizenship, you wrote this: federal courts do not exercise general oversight of the executive branch. They resolve cases and controversies consistent with the authority Congress has given them. When a court concludes that the executive branch has acted unlawfully, the answer is not for the court to exceed its power to. Some of your colleagues, including Justice Ketanji Brown Jackson, said that reasoning was a, quote, existential threat to the rule of law. I mean, that obviously got a lot of attention, that whole back and forth. And your response to her?
Yes, let's see. I do want to clarify that I was writing for the court. I always feel funny about saying, yeah, I was representing the court, so it wasn't just my own opinion. But I was the drafter of the opinion. And I think that Justice Jackson and I just had different views of the judicial power. Mine narrower, or the courts rather, narrower than the one that Justice Jackson.
Was it Justice Ketanji Jackson? I forgot her last name, but she was a Biden appointed judge. And the reason why I know her so well is because somebody asked her, what is a woman? And she was unable to answer that question. And she still got the position as Supreme Court Justice. I was like, wow.
Yeah, it's hilarious. I mean,
you
so
can
that's
literally
what I'm
look
saying.
it up.
So that's what I'm saying. An instance like that where someone is obviously has a deeply partisan view of things. It's a hotly contested thing. It shouldn't be a hotly contested thing, in my opinion, but it has become a hotly contested thing, and she cannot level with any sort of fairness. So anything that deals with trans rights or trans issues at all, she's going to weigh on the favor of the community versus the Constitution,
Man,
in my opinion.
it is what it is.
Has been presented. I hasten to add that Justin Jackson and I get along just fine. Justice Scalia used to say, I attack ideas, not people, and that's my motto too. So we were sparring about ideas. It was not personal. But I do believe that. I think the judiciary needs to stay in its lane.
And she wrote a solo.
Maybe not to her.
Correct.
Yeah. And you responded in an interesting way. They got a lot of attention. You clerked for the late Justice Antonin Scalia, who was known also to have a pretty sharp pen.
And shout out Daniel Castro. He says, then the media spins the story to sway votes every single time.
Bruh.
Every single time.
Times when it comes to your point of
Yeah,
view
Bush.
and style, how do you see comparing or contrasting to Justice Scalia?
It's hard for anybody to compare their writing style to his because he was such a fantastic writer. So I'm sure, my writing does not hold a candle to Justice Scalia's writing. In terms of the heat, he was Italian, so I think he had naturally brought a little bit more heat to the pen. So I calibrate mine to the situation, and in that particular opinion, I was writing, in a little bit more of a forceful or, shall we say, spicy way than maybe I sometimes do.
But as far as your point of view about the Constitution, a constitutionalist, the text, explain that for folks.
So,
in that way, you're close to Justice.
Oh, yeah, of course. In terms of philosophy, I did. I learned from Justice Scalia. And in terms of philosophy, my philosophy tracks is. And that is that the Constitution's text controls, and the way to understand what the text means is to ask how it was understood by those who ratified it when it became law.
And for the folks who say, well, the founders were dealing with completely different problems back then. They were not contemplating what a country could look like decades later. How do you?
Can I say something to that point?
You know what? Well, hold on. Let me take that one real quick because when I hear what they say when they've called to the Second Amendment, and I'm pretty sure our forefathers thought that, we're going to have more advanced weapons. And guess what? We want our citizens to have the advanced weapons as well, because you never know.
Yeah. So to that argument that that they make about the founders, it's funny how the founders in their era couldn't have predicted the country lasting, but somehow justices now are able to make decisions for the future. It's wild that you can make that argument in one breath and then sit there and talk about the future of the country in another breath. So it's like, well, do you think that nothing's ever going to change about the country as it is today? So in that case, should we listen to anything you say? Because you're only looking at it about today.
Bruh.
It's like the founders understood that the world was going to get technologically advanced. The founders understood that things were going to change. In fact, when the Second Amendment was written, there was advanced technology out there. Like machine guns were a thing, or were becoming a thing when the Constitution was being written. So this idea, semi-automatic weapons were a thing when the founders were writing it. So I would hope or venture to guess, because I'm not them, but they wrote that with the intention that the country is going to last more than 10 minutes.
Yeah, and on the argument of that they try to use for the Second Amendment, it is, like I said, it's funny because, what was the Second Amendment used for? So we can arm ourselves just in case we're invaded, or to go against an enemy, or our government turns into the enemy against the people. Don't you think we're gonna need, the same advanced weaponry that they're gonna have to go against that?
I mean, so just pull up the Second Amendment and read it and parse through the words and just look at how it's written and look at because the meaning of words has changed over the years. Think of like she said, when they wrote it, what did they mean when they wrote it? How did those words correlate? The necessary, the necessity. Fuck. You're talking about the necessity to keep a state free. Well, what are threats to a state? It could be a tyrannical government. It could be an armed
invading
rebellion. It could be
force.
an invading force. So because it's so necessary to keep the country free, the right to keep and bear arms shall not be infringed.
I mean, here's
And
the thing: like we're probably one of the few countries to where if an enemy was caught trying to head onto our shores, we could start shooting them before the military does.
yeah, and I mean, now in common law, post Geneva Convention, post UN, you're not actually allowed to do that. Like the citizens of a country are not allowed to take up arms against an occupying force, because that creates an insurgency, and insurgencies are technically illegal. Like you have to be a uniformed military member or a part of the militia, um, to fight off a force. And for those that love to point at the militia, yeah, there needs to be a militia, or the availability to rapidly create a militia. Think about how the Revolutionary War started.
Yo,
They
I ain't gonna lie.
created a militia. They
Yeah, go
created a
ahead.
militia out of the farmers in the fields
Man, I
that
ain't gonna
all
lie.
had their own guns, and they knew that when they wrote that.
I don't know, Monty. Maybe we need a militia in every high crime neighborhood. That might help.
We want a living, breathing constitution that changes. How do you respond to that?
You know, the genius of our Constitution, and I talk about this in the book when I describe originalism and describe our written Constitution, is that it's written at varying levels of generality. So sometimes it's very specific. The president has to be at least 35 years old. But sometimes it's very general. We're protected from unreasonable searches and seizures. We have freedom of speech. And to have freedom of speech doesn't mean that you have freedom only to pass out pamphlets in a town square. I mean, it means that you have freedom to be on broadcast news.
Yep.
Right. And the 22nd Amendment says you can only run for office for 2 terms.
True.
You think that that's cut and dry?
Well, that's what the amendment says, right?
Yep.
After FDR had 4 terms, that's what that amendment says.
Not asking how you think about an issue, but scheduling the tariff question. We think that will be in coming weeks.
I don't think that has been scheduled yet, but we certainly take into account requests to move things along quickly when it's necessary, but that one has not been scheduled yet. To my knowledge, you might have more current information than I do.
Well, I don't know about that. You live inside these walls here.
Actually, when are they doing the birthright citizenship one? Because like I remember when I was listening in on
I
some of
thought
these
it was
Supreme
supposed to be
Court hearings.
August, but
Yeah.
it hasn't happened yet.
Oh,
Or it might have been being scheduled in August for a later date. Um, but yeah, so and that's the beauty of our Constitution. Our Constitution allows for a Supreme Court to take up issues like this whenever there is a dispute on the text of the Constitution, and they're supposed to follow what the Constitution says or what their interpretation of the Constitution is. That's why people say it's a living, breathing document, because the living, breathing document comes out of the 9 bodies that are thinking in the day to day.
all right.
So they absolutely thought ahead and said, well, maybe in 100 years, or 50 years, we're not going to like slaves anymore. So we're going to make a mechanism in which we can free slaves. Or maybe in 100 years, or 200 years, or 175 years, they're not going to like alcohol, and then they're going to outlaw alcohol, and then they're going to turn around and say, well, maybe that was a bad idea, so that it can be continuously changed and updated through a constitutional process, which is why everybody hoots and hollers and says, if you don't like the Second Amendment, pass an amendment to change it.
Good point. All right, let's keep it going.
Spend some time in the book discussing the Dobbs decision and that overturned Roe v. Wade and the precedent ending the nationwide constitutional right to abortion, as it's so called. You write the court's role is to respect the choices that the people have agreed upon, not to tell them what they should agree to.
Yes. So the court's role, and essentially what the court said in Dobbs, was not that we were taking away a right, but that as properly interpreted, the Constitution did not protect that right. That it's one left, like virtually every question, to the democratic process. That's because the court, in interpreting the Constitution is our fundamental document. It's the super law. It trumps every other law. and it represents our fundamental commitments as a people that we have agreed to. And that's a product of the democratic process. That's not a product of what the court imposes on the democratic
Do you
process.
think that decision is misunderstood broadly?
I do. The Dobbs did not say that abortion is illegal. Dobbs didn't weigh in on that question. Dobbs said it belongs to the political process. And, you know, it's been thrown to the political process and the states have been working it out.
I mean, in fact, you write, getting ahead of.
Yeah, to the dislike of every pro-abortion person out there.
Yeah,
like,
so
I'll be honest, they want it to be a federal thing, but leaving it to the states. I mean, if you don't like your state abortion laws, I'm sorry, but yeah, you might just have to move then if it's that serious.
It's not abortion is not covered in the Constitution. Therefore, the Supreme Court has no legal authority to make an opinion on it because it's not covered in the Constitution anywhere. So what do? You have to make laws on it. The 10th Amendment says that anything not covered in the Constitution is left up to the states. Abortion is not covered in the Constitution, so it's left up to the states. And it has to be of the will of the people, and that's the constitutional process. Just because you think that abortion is some sort of a human right doesn't mean it is. Like,
even though it takes away human right.
It takes away human rights. And so there's right there, there's a disagreement between one group of the population and another group of the population. So therefore, it should not be imposed massively as a law across all 50 states when all 50 states don't agree on it.
Man, that's the facts.
The American people came at a cost.
Yes, Justice Ruth Bader Ginsburg, who was herself a supporter of abortion rights, pointed that out. I mean, when the court decided Roe, the country was already moving in a direction of liberalization of abortion laws. But the court.
All right, hold on. I'm gonna go ahead and read because I thought I read Castro's super chat, but then but shout out to my man Castro. He says then the media spins the story to sway votes. Oh,
You did read that.
I'm pretty sure I read that. Okay. All right. Thanks, Monty.
Ben was in the business of making a lot of pretty fine-grained decisions about abortion regulations that Dobbs held belonged to the political process.
Do you see the passion and how did that affect you, all of the fallout from that case in particular?
I think the fallout from that case drove home a point that I make in, I think it's chapter 2 of the book, about the cost of the commission and the oath. You know, you make decisions that are unpopular and you have to face what comes, right? So we don't expect that we will be popular, and sometimes that can be difficult to be subject of public criticism, but that's the cost of the commission.
In your nomination hearing in the Senate, Senator Dianne Feinstein said this.
When you read your speeches, the conclusion one draws is that the dogma lives loudly within you. And that's of concern when you come to big issues that large numbers of people have fought for years in this country.
That's about your faith. You write about your faith in this book. You say some suggest that people of faith have a particularly difficult time following the law rather than their moral views. I faced that criticism as a Catholic, most sharply when the Senate Judiciary Committee conducted a hearing to consider my nomination to the 7th Circuit. I'm not sure why. Are you still not sure why?
When I say I'm not sure why, it means what I meant to convey is that people who have faith and people who have no faith at all each have deeply held moral commitments. I mean, I'm fortunate to know many people who do not have faith, who have deep, deep commitments to values. And so I say in the book, whether you are pro-choice because you think you're a secular humanist, but you think it is a fundamental moral right of a woman to terminate a pregnancy, or whether you're a person of faith who is pro-choice because you believe the same, or you are a person of faith who is pro-life, everyone, every single judge, every single person has moral commitments. And I just don't think it matters from where those commitments come. They all must be put aside if one is to judge.
Your book has great pictures from all different times in your life, and also a picture that says 1,000 words as you write, a snapshot of two justices riding an elephant together in India, captures the relationship between Justice Scalia and Ruth Bader Ginsburg really well. Are those
Yeah,
relationships in this court?
Yes, I think that those relationships, I think what their relationship showed and what people talked about so much after Justice Ginsburg died most recently, is that they could vehemently disagree about ideas, but be close personally, have warm relations personally. And we work on that in the court, to maintain collegiality and friendship and warmth.
Can
despite
I
the
say
fact that
something
we
real quick,
have
Seth?
Yeah, go ahead.
So there's some discourse in the chat about the difference between federal laws and what the Constitution of the United States says. Federal laws must adhere to the Constitution, and if there is a an aspect of a federal law that does not align with the Constitution, it is not valid legally. Now, that doesn't mean it's not enforced, right? But it does not pass the constitutionality test. So if it's repugnant to the Constitution, it's not valid. The issue that I was bringing up is that abortion is not covered in the Constitution, and there has been no federal law protecting abortion's rights. Also, it's in the 10th Amendment that anything not delineated in the Constitution falls back to the states, i.e., what she was talking about, the political process. You have to vote on it. Abortion doesn't violate the Constitution, like having an abortion doesn't violate the Constitution in any way. And preventing somebody from having an abortion doesn't violate the Constitution in any way. So it's not in the federal government's hands unless they want to create a law on it, and someone can create a legal argument against the law or for the law. So just having a wide sweeping, oh, this is how it is not, nowhere in the Constitution does it talk about abortion.
Like trust me, the forefathers. I'll give them this argument. I know they didn't see that one coming.
No, they didn't.
I know the forefathers definitely didn't think, whoa, killing babies. Wait, what?
Which is why the 10th Amendment, or the 10th Amendment in the Bill of Rights was written, because they knew they didn't think of every single granular detail, and they said, well, if that's the case, then they can do one of two things. They can create a constitutional amendment where I think it's 2/3 or 3/4 of the several states agree on, or each state can create its own law governing it. And if that state violates the federal constitution, then you have recourse for that. You can take that to the Supreme Court and argue it, and then the Supreme Court can make a decision. And then that kind of extends the precedent for the Constitution.
I mean, shoot, well said.
disagreements, deep jurisprudential ones.
Are you concerned about security and where the country is going, specifically vis-a-vis the passion that you saw, the attempt we saw on Justice Kavanaugh, the security that you have to deal with day to day? Obviously, you have a large family, 7 children. It's a thing that a lot of public people have to think about. How do you think about it?
Violence and the threat of violence should not be the cost of public service. And so I know that the whole judiciary is alert to this. The Chief Justice has spoken about it. And yes, I'm very grateful for the security that we have. And it is something I'm worried about.
Public perception of the court, how important is that inside the court to all of you?
One reason I wrote the book is I want people to be confident in the integrity of the court, and I want them to understand our decision-making process. The court, however, can't take into account public opinion in making individual decisions, because the whole point of the court, and the point I try to convey in the book, is that you have to follow the law where it leads, even if it leads in a place where the majority of people don't want you to go. And that's because the Constitution trumps regular statutes, regular executive orders.
Thank you.
All those things that might be very popular in the current moment. The court has to stand up for the law.
So what about that? Do you like
Can
this?
I make a point on that?
Oh gosh, like
Oh
every
yeah, of course. Go ahead.
Right. So what she's saying is because this is why we are a constitutional republic, not a just a straight democracy. The Constitution sets the framework, not what a majority of people think, not what a majority of people want. And there is a legal framework to change the Constitution if you have a good enough majority. And that's why saying, oh, 68% of people believe women should be able to terminate pregnancies whenever they want doesn't matter, because it's not a federal issue, and it's not mob rule. Because in theory, if you live like that, in 5 years we could all decide that we all agree that murder is okay. If for example, someone touches your kid, right? We could make a law that says you're not guilty of murder if someone touches your kid. And
Best law ever.
I would agree, right? But that's not how our laws are supposed to work. Our laws are supposed to follow the Constitution. And if the Supreme Court takes that case up and somehow finds that that's unconstitutional, even if a majority of Americans agree with it, that's the reason we live in a constitutional republic with a representative democracy, not just a straight democracy. So all y'all freaking idiots out there that say, oh, Trump's a threat to the democracy and the Supreme Court's just letting it happen. No, he's following the Constitution and you don't agree with it.